Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. And in this video, I want to talk about the most common mistake that we see whenever someone's accused of having a consensual relationship with someone under the age of 18 and they're over the age of 18. Okay, commonly referred to as statutory rape. And the most common mistake that clients make, that those accused of having illegal relationship with a minor, or that they admit to knowing how old that minor really was. And they admit to having some sort of physical relationship with that person. And they make general statements. They make admissions. They speak to the police. They speak to their accuser without speaking to their attorney first. And that is the biggest, most damning piece of evidence that we see in these types of cases. So here's an example. Okay, let's say you are 20 years old and you are dating a 17-year-old, okay? Illegal per se in the state of California. The age of consent is 18. But there is no accusations that there was any, forceful type conduct or nothing along those lines. But still, a crime could be charged because one person's over 18, the other person's under 18. Okay, so let's assume, you have a falling out with this woman, and next thing you know, you get a call from her parents. Hey, we didn't know you were 20 years old. We're going to report you to the police. That call from the parents or that call from your ex-girlfriend could be recorded by the police. That is okay and allowed under law. It's called a controlled call. Okay, that happens far more frequent than a lot of people think. And a lot of times how that goes down is, hey, as you know, my 18th birthday is coming up, and oh yeah, sure, yeah, and I want to see you again, and then the accused makes a statement along the lines of, yeah, well let's wait until you turn 18 before we hook up again. Okay, well that's good, right? You're realizing that you probably should have waited to begin with under law. But what have you just done? You've just admitted knowledge that you knew that individual was under 18. Similar type mindset you need to have when confronted by law enforcement about it. Don't make stuff up. Don't be closing doors to your defenses by giving this ridiculous alibi or saying you didn't know or whatever. Politely decline to answer any questions without my attorney present. You're telling me you didn't know that she was 16? Again, officer, detective, I politely decline to answer any questions without my attorney present. That's it. That's it. Because then I need to prove that you knew or reasonably should have known, and they need to prove that you actually had some sort of physical inappropriate contact. And more often than not, the strongest piece of evidence against you or against our clients in these types of cases are our clients' own admissions to their accuser, to their accuser's family, to the police. General principles of criminal law here and criminal defense apply. Confronted by an accuser, confronted by law enforcement, do not confirm you were on the planet at the time the accusation was made. Don't lie. Don't start saying, I wasn't there, it wasn't me, I didn't do it. Look forward to having my attorney discuss this with you at a future date. What's the best time they could call you? Will they have an attorney or not? And then go out and get a quality, locally experienced criminal defense firm to represent you, to protect your interests, to protect your freedom, to protect your reputation, and to protect your future. Hope this video has been helpful. Again, my name is David Shapiro, San Diego criminal defense attorney in San Diego. Obviously, law office of David P. Shapiro, where my firm helps good people regain control of their future when charged with a crime. 619-295-3555.